an urgent application. F2. This is against police harassment.
Against?
Police harassment, gundas of the police. An old man, 69 years of age. He was in a rental house. He was thrown out. Everything was
Is
gone.
it before this bench?
Yes,
Huh?
yes.
Can it, it's an, we can,
No, not BB1. BB2. Yeah. Other day I moved a petition like this.
why not tomorrow?
My lord, this is very urgent. The man was thrown out of the house on last 16. One, he is just loitering here and there with a torn shirt, no warm cloth. He's quivering at night.
Huh?
He's quivering at night.
Is?
Quivering at night, trembling and quivering.
I'm not getting what you're saying.
My lord, he's shivering
He's shivering. Okay, he's shivering.
for last 1 week. He
He'll be
cannot-
shivering for the last 1 week.
His house was locked. He was thrown away by gundas at the behest of police and the landowner.
I think police atrocities matter are there before court number 8.
I think so, not before us. Not before us.
No, it is a matter of division bench.
No.
No, my lord, other day I moved here.
You
Division
see,
bench.
Mr. Counsel, you see, Mr. Counsel, we have got the matters that can be heard by the special division bench. It says death reference cases, criminal appeal, including Hill appeal, criminal appeal, all criminal appeals.
And court number 8, Lordship will see.
Not before this bench. Sorry.
Court number 8 it will be. It is
My
the
lord,
roster is
he will also refer my
police and
submission.
army actions. 8 or 8 or 8 or
It's a division bench matter.
no, yes, division bench is sitting in 8. Justice Bhuja Buru and Justice Fukan. Court
Not-
8.
Court number 8.
My lord. If they refuse, again I'll come.
Huh?
If they refuse, again I'll come.
One and
The
amicus
jail
curiae will be
appeal.
appointed, my lord. Jail appeal.
Right, this is a jail appeal challenging the impugned judgment and order dated 23/12/22 passed by the Sessions Court Biswanath Charyali in Sessions case number 36/2020, by which the appellant has been convicted under section 302 IPC. Admit the appeal, call for the NCR. Issue notice. Ms. B. Buyan,
She will accept notice on my behalf.
Ms.
M. Chakraborty.
M. Chakrabarti accepts notice on behalf of the state, on behalf of Ms. B. Buyan, additional PP for the state. What do we appoint?
This is her name is there.
What is your name?
T. Begum. Tasmina Begum.
T. Begum. Okay. How many years have you practiced, madam?
10 years, Lordship.
10 years?
Yes.
Okay.
My name is before division bench.
Okay, Ms. T. Begum is appointed as amicus curiae. In this case, list the matter after receipt of the LCR. Yes, what is your name?
SI Akan, Your Lordship.
Huh?
SI Akan.
Mr. S.I. Akand, learned counsel for the appellant, submits that the impugned judgment and order
2012-2022.
2012,
Yes, Lordship.
22, passed by the special judge Pokso, Kokraja in special case number 12 of 2020, by which the appellant has been convicted under section
6A.
A,
6(1).
6(1) of the POCSO Act should be set aside. Admit the appeal, call for the LCR.
Lost.
Miss
M. Chakraborty.
25 years.
Miss B. Boyan, additional PP appears for the state. This is the matter for, no, this is the matter on receipt of the LC.
Lordship, can notice be go because the POCSO matter?
Okay, POCSO, I don't know. There's a big problem. Now, what to do matter?
Yes, in case of POCSO, it is required to issue.
No, but what happens supposing someone files the case? Now, what do you, will also.
Will also, they have to wait for that.
They have to be for 1 month.
Yeah, 25 years of jail, 25 years of prison.
Okay, with issue notice, okay, right.
Who is it? Father of the informant?
I don't have the papers.
Father of the informant.
Okay, right. Issue
Part of the
notice,
victim.
Father of the victim.
Father of the-
Respondent number 2.
issue notice, returnable in 4 weeks.
Lost.
Issue notice returnable in 4 weeks. Miss so-and-so accepts notice, then petitioner, appellant to take steps for service of notice upon the response number 2 by registered post with AD within 3 days.
Lost. Deeply obliged.
Yeah, my lord, appealing conviction, my lord, under 302 by 34, my lord.
Okay.
Against judgment and order.
Heard, Mr.
R. Ali Lordship on behalf of A. Chaudhary.
What is your name?
R. Ali,
Your name is not here.
I am praying on behalf of A. Chaudhary, my lord.
Mr. R. Ali appears on behalf of Mr. A. Chowdhury.
My lord,
So, sir, the challenge in this appeal is against the judgment dated 21/12/2022,
my lord,
passed by the Sessions Court Nagaon in Sessions bracket T-I, T-1, bracket close, case number 74 bracket N of 2014, by which the appellant has been convicted,
appellants, my lord,
appellants,
7 appellants.
7.
by which the appellants have been convicted under
Section 30234. I guess.
section 302/34 IPC. Admit the appeal, call for the LCR. Ms. B. Buyan appears for the state. This is the matter after receipt of the LCR.
My lord, the judge one, IA, my lord.
In the IA,
I'll file objection, my lord.
Ms. B. Buyan, additional PP is granted.
3 weeks time, my
3 weeks time to file
I am obliged,
written objection.
my lord.
This is the matter
obliged, man.
Julie.
after 3 weeks.
Legislative appeal against conviction.
Huh?
Legislative appeal against conviction also within time.
Right, heard Mr.
K. Ahmed.
A. Ahmed, learned counsel for the appellant, who submits that the judgment dated 21/1/2023 passed by the Special Court POCSO, Baksa in Special POCSO case number 114/2018, by which the appellant has been convicted under section 4 of the POCSO Act 2012 should be set aside. Admit the appeal, call for the LCR. Ms. S. Jahan, additional PP, accept notice on behalf of the state. Notice be issued, no, petitioner appellant to take steps for service of notice upon the response number 2 by registered post with AD within 3 days.
IA is there.
Huh?
IA is there.
This is the matter after receipt of the LCR. In the IA, madam,
Lordship, 2 weeks.
Ms. S. Jahan, additional PP is granted 2 weeks time to file written objection to the application for suspension of the sentence and bail.
Obliged.
In the other one, no,
Five
don't, the
counts.
3 weeks, cut that, no need. Because one was said after receipt of the LCR, so just cut that. Item 5.
5 councils are not there. There must be a delay of some days. This is a jail appeal.
One for you will allow. Oh, well. It is by the
Yes, yes, appellant
jail
being in
appeal, no?
jail.
Jail appeal, will allow this.
Lot.
Okay, right. Heard, no, not heard. This is an application under section 5 of the Limitation Act 1963 for condoning the delay of 114 days in filing the jail appeal against the judgment and order dated 29/1/2022 passed by the learned special judge Foxo Kokraja in special case number 1/2020, by which the appellant has been convicted under section 3. This is a Foxo case. This is Foxo. Special judge Foxo. Acha. Acha. Section 6 of the 302 and 6. As under section 302 IPC.
376 AB, IPC and 6.
No, but I think at the end it will be Foxo only. No?
302 along with 6 is very unusual. I mean, I've not got it.
Huh?
302 along with 6 is a little unusual. COVID no mouse. Okay.
Let us see, convicted.
Monji. Monji to along with the sap course.
376 and 6, no separate sentences.
Hmm.
He was convicted.
Maybe you should file an appeal also.
Acha. Acquitted of something.
No, not acquitted, because the appellant has been convicted under section 302, 376 and 6.
Bapre.
376 and 6, same sentence.
Huh.
So, but however, since he has already been convicted for life under 302, so no need of sentencing him under 376 of POCSO.
I think section 44 of POCSO Act provides that higher offense.
Correct, no, but he's saying that 376 and 6 are giving the same sentence.
But then.
So there's no requirement, but however, there's no requirement of sentencing them under 376 or 6. In view of the fact that he's already been sentenced under 302.
302.
So no sentence has been provided under 376 or POCSO. So maybe you'll have to file an appeal.
But
No
we'll have to see that.
No separate sentence.
But convicted, no?
Convicted is
But
okay.
convicted,
Sentencing
no
was done
separate
only under
sentences.
one of the
It should have been
offense.
You see, if he's convicted under a particular section, he has to be sentenced either under 376 or POCSO.
No, that is the prerogative because there is no bar in convicting in convicting in all the sections and sentencing only 1 or 2.
No. 302 is a different offense altogether.
Yes.
376 and POCSO are another offense altogether. So when 376 and POCSO provide for a minimum sentence, can you say that you cannot sentence?
But there is a specific provision in the POCSO Act saying that a person can be convicted but sentenced under the higher offense and not required to be sentenced under the other offenses.
Provided it's under, let us see that section.
POCSO Act, Lordship, section 44, and 41. 42, yes. Section 42 of the POCSO. Perhaps 302 will also be included there.
Okay, let us. 42,
Huh.
Maybe 40.
alternate punishment.
Huh.
Where an act or omission constitutes an offense punishable under this act and also under sections 166, 340, 354, 345B. So and so, so and so.
Now,
302 is not there.
no, Lordship will say section 42. If the offender is found guilty of the offense under such other law,
No,
he is
42.
like, what it, Assam POCSO Act? I think 302 will be included for the offense
No,
and the other law. I'm not, I
no,
don't know
No,
why.
madam, yeah,
42A perhaps.
42A. 42A. The shall be in addition and not in derogation of the provision.
Oh, no.
No.
Lordship
Just-
42, Lordship 42, Lordship will go to the below part.
Below part.
Under any other section of so and so, here 302 is not included. in-
Not included.
That notwithstanding anything contained in any law for the time being in force, the offender found guilty of such offense shall be liable to punishment under this act or under the IPC as provided for punishment whichever is greater, or under IPC, but IPC these sections are provided for. Three zero two is not included. And also under section so and so, so and so, so and so of the Indian Penal Code or information, then notwithstanding anything, the
Yeah.
offender found guilty of such offense shall be liable to punishment only under this act or under the IPC as provided for punishment which is greater in degree. Now, 302 is not mentioned in the chart. It's 354, 370, 376, all this.
Then anyway, that is up to you if you want to file an appeal or not, because now the only, supposing this court comes to a finding that he cannot be convicted
Hmm.
under 302,
two.
then what happens? Then he has to be free, set free. He's not sentenced under those. POCSO
I
Act
will
or the
see
IPC.
because conviction is there, only sentencing not there. So I'll see whether High Court can do it if they find conviction is cannot be provided for. I'll see, I'll look into that aspect.
But this is the appellate authority.
This is
Then-
appeal.
Then why should this then where is the chance for him to appeal?
And
Then you'll
376.
be taking away his right to appeal against the sentence.
They have to go to the Supreme Court. And 376 is not a lesser offense also compared to 302.
Whatever it might be. So anyway,
Lordship, I'll
there's
see.
food for thought.
Yes, of
You'll
course.
think about it, because if he's not sentenced
Mm,
for an offense of rape,
mm.
then we are taking a chance with regard to the 302.
Two only
sentence.
now.
Huh?
We have to confine ourselves to 302 only now,
No, you don't have to confine yourself, but yes, in a way.
in a way, because he's acquitted. He's not acquitted.
He's not acquitted, but
He's not sentenced.
So maybe. But that's it. You have to remand it. But then there is no appeal file. You
no.
file an
Yes.
appeal.
No, we have to get an instruction again. But he is convicted, otherwise not sentenced because
Convicted,
higher
yeah.
offense is there.
So the sentence should be given, no? No,
Ah.
higher offense, not with regard to the same crime.
Not be
302 is
in-
with regard to
Ah.
murder. 376 and 6 is with regard to rape.
Ingredients are totally
So-
different.
That's what. So that 42 is on a different footing, I think. Except there are some, of course,
Huh.
there are some specific sections given under that.
There are specific 302 is not there. That creates problem. I'll see, I'll
Yeah.
try to take out
So what have we
decisions.
said? Say zero to IPC and sentenced to undergo life imprisonment. Wait. Sentenced to undergo just to undergo life imprisonment with a fine of rupees 10,000 in default imprisonment for 1 year. No RISI, nothing. Full stop. Further, though the appellant has been convicted for the offence under section 376 capital AB IPC and section 6 of the POCSO Act, no separate sentence has been passed in terms of section 376 AB IPC or section 6 of the POCSO Act on the ground that the appellant has already been sentenced to imprisonment for life under section 302 IPC. So what do we should do?
Admit that.
Registered, appeal may be registered. Appeal may be registered now.
No, should we allow the 114 the condonation?
Lordship, yes, sir, because it's a jail appeal, Lordship.
Yes,
has
actually at
decided.
the end we'll have to do it anyway.
How many days delay, of course. I didn't
114
say.
only.
Oh,
Not
acha,
much,
acha,
not much.
Lordship can do.
Okay, let us see what are the grounds taken. That's right. On considering the grounds taken, no, that's right, Miss S. Jahan, additional PP submits that she has got no objection if the delay is condoned. Full stop. On considering the grounds taken in the application for condoning the delay and keeping in view the submission made by the learned additional PP, the delay of 114 days in filing the appeal is condoned. No, we find that the delay of 114 days, the reasons for the delay, we find that sufficient cause for the delay has been made up. Accordingly, the delay of 114 days condoned, I is accordingly disposed of. Then in the main case, you're right. This is a jail appeal, so it's the same thing, no? You're right. What is issue notice before that, right? Admit the appeal, call for the MCR.
Case was registered, not
Oh.
registered.
No, yes, appeal is not registered.
Then you write in the IA. You write in the registry to register the appeal and list the same in the next week.
Lodge. Six way filer objection, my lord. It's on record.
Yes. What
May
is your
please
case?
Lord, I for stay of, my lord, sentence and, my lord, suspension of sentence and stay of fine.
Stay of fine.
Yes, my lord, stay of realization of fine and suspension of sentence, my lord. Till the pendency of this particular case, my lord. And at the time of, my lord, when this matter was initiated, my lord, he was on bail and never misutilized the, my lord, liberty granted to him. My lordship will find the judgment at page 34. May I take directly, my lordships? Page 34
34 of what?
of the, my lord, my
Of the
eye.
IA.
Yes, my lordship. Lord, the prosecution case in brief is that on 27/2016, the complaint, this at this date is the FIR was lost, my lord. And if my lordship may kindly see para 5, that is point for determination, whether the accused person on 27/2016 at village so and so under so and so committed rape upon the victim. Lord, but this is not the date, my lord. This is only the date of filing of the FIR.
But she
The
became
case-
pregnant.
Yes, my lord. It was, my lord, 8 months back, the case has been filed. After the commission of alleged offense, after 8 months, my lord, this particular case has been filed. And my lord, the date on which the alleged offense took place, my lord, that is not ascertained, my lord. The date is not there. But that is not my case, my lord. My case is that, my lord, the allegation, there are, my lord, 8 numbers of witnesses in this particular case. 3 are, my lord, interested witness, that is father, mother, and the prosecutrix. 2 are the independent witnesses, 1 IO and 1 MO, my lord. The case has been filed as per the allegation of the, my lord, the informant. The case was filed when the, my lord, prosecutrix got pregnant, her menstruation stopped, and it is when they came to know that because her menstruation has stopped, it is only then it has come to their knowledge. And at that particular point of time, she was 8 months pregnant, and on being asked, she has
4 of explosive substance act.
Oh, explosive substance.
Yes, Lordship. Sir, here is the IA before your lordship is a delay condemnation petition of 1234 days in preferring the appeal. Lordship. And here is
So you want time?
Yes.
Okay, right.
And a
Mister,
copy of IA be given to us, my lord.
they
I
have
don't
not
have
given
a
copy
copy.
of the IA.
already given without.
No,
holding-
now I don't have
It is not
anything.
listed perhaps, Lordship.
Huh?
Extra copy be given to
Oh,
us.
extra copy I'll.
Okay, heard, Mister
B. Haldar, Lordship.
B. Haldar. Learned counsel for the applicant who submits that there is a delay of 1, 2, 3, 4 days in filing the appeal against the impugned order and sentence dated 17/7/2017 passed by the learned session judge Morigaon in sessions case number 39/2017, convicting the applicant under section 120 bracket B, capital B, /307/511 IPC, read with section 4 of the Explosive Substances Act, and by which the applicant has been sentenced to undergo rigorous imprisonment for a term of 10 years and to pay a fine of rupees 25,000, in default, RI for 1 year.
Here, Lordship, maximum
Oh,
punishment
good.
was imposed life,
RI
imprisonment for
for,
life.
no, okay. For 1 year, then yeah, for the offense under section 120B, full stop, IPC. The applicant has also been sentenced to 10 years imprisonment.
Yes, Lordship. Imprisonment for life, Lordship, for offense.
Okay,
under
don't say
section
all that,
4.
forget that. Just say convicted. Convicted and sentenced accordingly. And then who is the respondent number 2?
Respondent number 2 is the informant, Lordship.
Not required. What did you blast?
Lordship, the informant allegation was that while the informant was sitting in his shop, Lordship, some polythene bag was thrown in front of the shop of the informant, and it was like grenade-like articles, Lordship.
It
But
was?
grenade-like articles, Lordship.
Okay.
And 3 persons were, Lordship, charge seated in this case, Lordship. What
There
we
was
did-
no blast.
There was no, the prosecution has failed to prove that there was a substantive.
But you pleaded guilty.
Yes, I pleaded guilty, Lordship. But what happened in this case, Lordship, although the guilty was pleaded by the appellant, Lordship, there was no evidence to show that he was given informed that he has the liberty, he has the freedom to not pleading guilty, Lordship. And no separate
Okay,
statement was
anyway, issue
recorded.
notice, Ms. B. Boyan for the state.
J Das will accept notice.
Okay, issue notice to the respondent number 1. That's
I
all.
leave it to your lordship.
Huh?
I leave it to your lordship.
I don't think number 2 is.
I don't think.
Number 2 is not written. It's not written.
May not be required. If
Issue
your lordship
notice to the
wishes.
respondent number 1. Mr.
J Das.
J. Das appearing on behalf of Ms. B. Boyan, additional PP, accepts notice on behalf of respondent number 1 and submits that written objection will be filed within
2 weeks.
2 weeks. This is the matter after 2 weeks. Was it this POXO?
No, Lordship, here Lordship 376-1. Victim was aged about 48 years and appellant was for 20 years at the time of alleged occurrence. Lordship. She was
So
married.
there's
she was-
143 days delay. Any objection?
143 days.
One-
Lordship,
143.
I'll fill that.
Okay, right. Mr.
Yeah, Ahmed.
Learned counsel for the applicant submits that there is a delay of 143 days in filing the appeal against the impugned judgment and order dated 26/7/2022 passed by the Learned Sessions Court Bongaigaon in Sessions Case number 49(M) of 2018, convicting the applicant under section 376(1) IPC and sentencing him to undergo RI for 12 years and to pay a fine of rupees 50,000, in default, SI for 1 year. Ms. B. Boyan, the additional PP submits that she has got no objection to the delay being condoned. On considering the grounds of delay provided in the application and keeping in view the submission made by the learned additional PP, we find that sufficient cause for the delay has been made out. Accordingly, the delay of 143 days in filing the appeal is condoned. I is accordingly disposed of registry to register the criminal appeal and the IA for suspending the sentence and list the same accordingly. No, for stop, list the same in the next week.
Obliged.
I've got a very serious sore throat.
Oh,
Anyway, I will continue for some time.
if you want to adjourn, to no problem if you've got a sore throat. Depends upon. you.
Problem নেই কোনো করে
We leave it entirely up to you.
My lord, today is 22nd. Can it be on any hearing date, my lord, in the first week of March? Because it will take some time, my lord, at least 3 hours.
No, that is all right. Time to we have got.
Yes.
That is not
Murder,
an
murder
issue.
case, my lord, 302.
Huh?
Murder case, 302.
No, you see, time to we have got. Don't worry about time. But since you have got a sore throat, and if you don't feel up to it, that is a different issue.
Any date, my lord, on the first week of March. Man is in jail.
Second week of March, basically. First week of March.
Yes.
lordship, there will be
Hearing-
holidays
hearing
for 5 days holiday. 4 days holiday, then
Uh-huh.
thereafter, the week thereafter, 14th, first week to holiday আছে না?
The ninth
Holy
is
Tane?
9th.
9th or on this one 14th, your
14th.
lordship?
Okay.
কেতিয়া? 14th.
Okay, right. Mr. R.P. Sharma, Learned Senior Counsel, appearing for the appellant, submits. Now, phrase that the matter may be adjourned till 14/3/2023. As he's suffering from a sore throat. Miss B. Buyan. Learned additional PP submits that she has got no objection to the said poster. In view of the learned senior counsel for the appellant suffering from a sore throat, list the matter on 14/3/2020.
Response number 2, madam.
Mr.
Information.
Okay, you say Mr. B. Buyan and Mr. D. Bora for the point number 2. Submit that there was no objection. Huh? This is over. Huh? The hearing this is there, no?
Hearing list is there. Who will be? 2.
Yes. You shut it off.
One of
Son hacking father.
Yes.
Eyewitness is there.
2 eyewitnesses, the younger brother and younger sister of the accused. There are 7 siblings. Informant is also one of the brothers.
So who are the eyewitnesses?
Eyewitnesses are
PW?
PW5.
PW5.
She is around 12 years, the younger sister of the
Yeah.
accused.
Younger sister of appellant.
And PW6 is the younger brother who is 10 years.
PW5 and 6.
PW5 and 6. The prosecution story is that the
So
son-
there is no doubt with regard to the death of
Yes,
the,
in
at the
fact-
hands of the
in
appellant.
fact, in 313, the accused admits.
Okay.
So that part, only in the manner it has been done, there is a little bit of.
So you are trying to bring it under the exceptions or what? No.
My lord, in 313, when the questions was put before the accused, he tries to explain in what situation it happened. That
Okay.
is, he says that it was during a scuffle. Therefore,
Okay.
he did not have the intention. However, the story version of the eyewitnesses is that when that day was a Bihu celebration. So when the father came back home in the night, when he was entering the home, the accused was coming from outside and he called his father. So when the father goes out, the accused cut his hand first. He falls down, cut his neck.
No.
This is this version of the.
What time was it?
I think around 11:30
At night.
at night. So this
So,
is
okay. Were they in a drunken state or what?
in the 313. The accused says that they both were intoxicated.
Both.
Both. He says we both were intoxicated, and in 313 he says it was the father. When he comes back home, the father from inside abuses him, goes out with a column kotari, a
What is
knife,
that? Okay.
and then they got into a scuffle. During the scuffle, the father got injuries and he died.
It was a knife.
It was a knife.
The knife that the father took out
That-
was used by the.
That is his version in 313. So this is basically the thing before. So here, I was trying to examine very carefully the versions of the child witnesses, because they being child witnesses, we have to see whether it has been said, whether they have really seen what they have said.
Mhm.
Now,
Now PW5 is how old is the sister?
PW5 is 12 years,
And 6 is 10 years.
6 is 10 years. And the informant is one of their brother who was sleeping inside. That
Informant is PW number?
PW1. He was sleeping inside the house. Both the
Yeah.
the sister goes and calls him, and then he comes
He's
out.
the younger brother again? or-
No, he is the elder brother. In fact, now PW1 is managing the household. That has come in one of the questions that the court put when the court was testing whether the child witnesses are competent enough to understand the questions and report.
How old was the appellant at the time of the incident?
Appellant, I think, is
28
about
years,
28 years.
At the time of the incident?
Yes, 18, same year.
Sure, 28.
313, it's recorded in 18 itself.
So he was 28 years.
28 years.
28 years still living with his parents.
In fact, they all, I think, were staying together only. Even the elder brother,
28 years.
PW1, he's about page 8.
It's quite different from the West. Huh? Once you are 18, you've got
Yes,
to go out.
yes.
Yes, that was
In
the
the
right thing.
villages, generally,
Huh?
in villages, they
Yeah.
generally stay in the same compound.
Ah.
And now, of course, in the cities, once the children are married, they started
Yes, yes,
staying differently. But
No,
villages,
then
the joint family
So
system is still there.
basically, this is the fact that he was killed by the son is not in doubt.
That is admitted.
Admitted. Only thing
He
is
himself
whether
admits.
exceptions can come into the
Correct.
exception.
That is the only thing. That is it. So I will just, if your lordship allows, I can read the FIR, PW1
Yes,
and then
sir.
5 and 6, and then 164. Your lordship will find the FIR at page 4. May I read it, my lord?
Yes.
Page 4. This is dated 14/1/18. Though there is an error, it is mentioned 18. That date should have been 14.
FIR is 14.
14/1/18.
Yes.
Humble submission that at about 11:30 p.m. yesterday on 13/1/18, my own brother Shri Amit Sabar had called away my father Jibon Sabar from home and killed him on the road near our house by hacking on the neck with a pruning knife. Then PW1, your lordship will find at page 8, that is the informant. He's about 20 years. So the accused is the eldest. I am the complainant in this case. The deceased was my father. The accused,
So informant is also younger brother.
younger brother, 20 years.
Yes.
The deceased was my father. The accused person is my own brother. The incident took place around 11 p.m. on the day of Magh Bihu Uruka this year. I was sleeping at my house. My sister, she is PW5, awakened me and told that elder brother had cut father. Then I came out from the room and saw father lying at the threshold of the house. There were cut injuries on the neck and hand of my father. There was cut injury below the neck. My father told me that accused Amit had cut him. However, my lord, your lordship will find that during cross, it comes out that this was not mentioned during before police.
Because police already knew it.
After committing the incident, the accused person fled away, but Raju Monokan and I apprehended the accused person and kept him tied to a tree and informed the same to the Titabar police station. While police personnel arrived there, the accused person confessed that he had hacked Jeep so-and-so with a pruning knife. Thereafter, I lodged an ijahar with the police station. I put my thumb impression. The accused person hacked father with the dao, which has been shown in the court today. Today, I have seen so-and-so, the dao. Thereafter, the doctor held post-mortem examination on the dead body of my father. Police arrested my elder brother and took him away in cross malice. The ijahar was lodged on the following day of the incident. I do not remember the time. I am illiterate. On being asked by police, one of our neighbor wrote the ijahar for me and read over it to me. On the day of the incident, we had arranged a feast near our house. The accused person used to work at Jorhat and he went to his house 1 week before the incident and was in his house. So the accused was not staying with them. Accused was working at Jorhat. The incident occurred on the road and father ran towards the house and fell down near the plinth of the house. The houses of so-and-so are near the place of occurrence. Our house is situated at a distance of about 100 to 150 feet from the road. I don't know, this may not be relevant. Next page, page
What do you
10.
mean plinth, whatever? What is this?
This is the distance.
My father reached the
that is
plinth.
the steps for the courtyard. The edge, I think, no? Edge of the courtyard. In the next page, your lordship will see, I did not state before the police that father said to me that the accused had hacked him. This is what I was pointing there.
Because police
Then your lordship will come to PW2 is the son-in-law, PW3 and 4 are neighbors who are the Caesar witness. Nothing much relevant. Your lordship may straight
So
away
there
come to-
was a dying declaration.
Yes. Your lordship may straight away come to PW5, page 19. She is the daughter who is about 12 years. Your lordship will find the age at the top, aged about 12 years. My name is Munni Sabbar. Then your lordship will see that as the witness is a child witness, I therefore put some questions to the witness to ascertain her maturity of understanding the question put to her by the court. Then few questions were put. Those answers I will not read out, but in the next page there is one, the last question, if your lordship sees, presently who resides in your house? Elder brother, Bimol, younger brother, second elder sister, brother-in-law, and I am residing. So they all reside together. Elder brother is maintaining us by working in tea garden. Then your lordship will find the evidence in chief. Elder brother is the accused in this case. The incident took place on the day of Uruka of last Magh Bihu. The incident took place at night. On that day, father went to the uncle's house for dinner. I was at our home. As our father did not return for a long time, Rahul and I were waiting for him.
Who is this Rahul?
Rahul is PW 6. Then my father returned home. While my father entering the house, the accused person called him with verbal abuse. The accused person started to abuse my father with filthy language from the road. Our house is adjacent to the road. After that, when my father came out, the accused held him and cut in his hand. And then he pushed and felled my father on the ground and again cut in the neck of my father. I have seen this incident. While my younger brother and I went near to our father, the accused person threw the pruning knife towards us. Then my younger brother and I returned to our home out of fear. Thereafter, father somehow managed to reach the threshold of our house. This is the plinth that PW1 was mentioning. After that, the accused fled away. So this is the exact narration that PW5 says. That first he cuts in the hand, father falls down and then cuts the neck. And then when they were trying to go, the father throws a knife away. While we were there, if I may just take your lordship to page 81, where her 164 statement is.
Page 81.
Page 81.
Yes.
Page 81, your lordship will see her name, so and so. Then some questions were put, and later at 82. Amit is my elder brother. May I read, madam?
Yes.
At about 11 p.m. on last Saturday, Amit came to our house and called my father to come out of the house in filthy language. Then father come out of the house. My younger brother Rahul, PW6, and I also come out. Then Amit pushed my father and felled him on the road. After that, at first, he cut my father on his hand and then on the neck with a pruning knife. When we went there in a run, he threw the knife towards us. Father somehow managed to come from road and fell down at the threshold of the house. After that, father told me that Amit had hacked him and then he became unable to speak. Then our uncle so-and-so came and Amit fled away. So the only a minor contradiction as regards the manner at the very beginning, she said that it is he cuts the hand, he pushes and then cuts the hand and neck. Amit pushed my father and felled him on the road. After that, at first he cut my father on his hand and then on the neck. And in court, she said that he first cuts the hand, father falls down and then cuts the neck.
Same here also.
No, my lord, your lordship will see. My younger brother Rahul and I also came out. Then Amit pushed my father and felled him on the road.
Yes.
After that, at first he cut my father
On his hand.
on his hand
Yes.
and then on the neck.
So same thing outer also.
After pushing and falling. Now, if your lordship,
So which came first?
just the
That's
manner.
thing.
I'm just pointing it out.
Those are my very
Well,
minor.
that's why I said minor, but one never knows what strikes. So I thought it's my duty to just put that.
Okay, so out here in the other one, first cut, then threw on the ground,
Correct.
then cut the neck.
Correct.
So out here, first on the ground,
Yes.
then hand,
Yes.
then
Yes.
neck.
And then I will take your lordship now to the
So
brothers.
anyway, whose statement is this?
This is the
statement by
doctor. Now the brothers is PW 6.
Why should it be 164?
It was registered, it was recorded by the magistrate during investigation.
But then generally what happens, because they are child witnesses, they might later on retract. So normally,
But
as
it is
part of
done.
investigation, they sometime record it before the magistrate.
No, okay, but then, okay. Then
Why
what
not?
else?
That is why they
Yeah,
do.
normally it is done.
Normally, that is why it is done. Some vital witnesses, sometimes the police think that we might need them and they might retract. So they just, for precautions, they just keep to the 164. Yes, in addition to the 161s.
Yes, okay. Then,
Now your lordship may come straight away to PW 6. I am not troubling your lordship with the other part of PW 5 because that is regarding the, if your lordship wants, I can read out the entire PW 5.
yes, better.
Okay,
Just in
okay,
case.
okay. Then we come back to page 21. I had
Yes.
stopped at the second line. Now your lordship will see. Then my younger brother and I returned to our home out of fear. Thereafter, father somehow managed to reach the threshold of our house. After that, the accused fled away. Then younger brother informed elder brother Bimol, who was sleeping then. Then my elder brother and so apprehended the accused person and kept him tied to a tree. After that, elder brother informed the police. Then the police arrived there. On being shown the down near the wall in the backside of our house, and police is the same. I saw the dow being taken out. Today I have seen the material exhibit 1, the pruning knife in the court. Father died at home. Later on, police took me to the court and I gave my statement in the court. So and so is my statement. So and so are my signatures. In cross, my lord. The house of my uncle is situated near our house. I did not go to the house of my uncle. I don't know how many people participated in the feasting at my uncle's house because I didn't go there. My uncle's house is at the backside of our house. The incident occurred in front of our house. There was a bit dark in front of our house. I witnessed the incident in the light of the electric bulb located near our house. It is not a fact that I did not see the incident. Beforehand, we had cordial relation with our elder brother, but after incident of hacking, we do not keep any relation with him. So there is no suggestion that the relationships were also bad. It appears that they shared a cordial relationship before the death. I did not state before police that elder brother concealed the dow beside the wall of our house and keep
This
it.
elder brother is who? The appellant?
Accused.
Accused, yeah.
The eldest is the accused.
Yeah.
And then I think it's the informant. I did not, my lord.
yes.
I did not state before police that elder brother concealed the dow beside the wall of our house and keep it covered with a piece of timber. It is not a fact that today I have not seen the knife in the court, which I saw in the court. I did not state before police the fact that villagers kept the accused tight. It is not a fact that the accused did not kill his father by hacking with a pruning knife.
Okay, so the dao and the knife are two different weapons. So dao has got nothing to do with the incident.
No. Now, PW6, your lordship will find at page 23, who is the younger brother Rahul, who is about 10 years. Similarly, questions were put to him to ascertain whether he can understand and can.
So to the same effect.
Same effect. Then at page 24, the evidence in chief starts.
Yes.
The accused person is my elder brother. The complainant is also my elder brother. The deceased was my father. The incident took place on the day of Uruka of last Magh Bihu. On that day, I was warming myself sitting beside a wood fire at home after having meal. Bimol was sleeping, that is PW1. Father went to the house of my uncle to take part in the feast. My elder sister and I were waiting for our father. When father returned to our house, the accused called him from the courtyard. Courtyard of our house and the road are adjacent. The accused called my father to come out of the house in Pildi language. Then my father come out. Then the accused dealt cut blows on the hand and neck with a knife and fell on the ground. So PW6 says that he first cuts the hand, cuts the neck, and then the father falls down. Now, we witnessed the whole incident. If I may just pause here and take your lordship to the 164, which is at page 84. Page 84 is Rahul Sabbar, 164 statement recorded. Page 85, the relevant. Amit is my elder brother. On the day of the incident, father was at home after enjoying the feast. Then Amit came to our house and called my father to come out of the house in Fildi language. Father came out of the house. Then I also accompanied father to the courtyard. When we went towards the road, Amit pushed my father and felled him on the road. After that, at first he cut my father on his hand and then on his neck with a pruning knife. So 164 is consistent of their both version that he pushes the father, cuts the hand and cuts the neck. While giving the evidence in court, their both versions are just that little bit of that, how the blows was inflicted. But I'm just pointing it out.
And when for a drowning man, you've got to clutch at straws.
And it was not very late also, like it was.
No,
only
no,
after
you see,
2
when
months.
you've got your back to the wall,
My lord.
and when you're the amicus, you've got to find out something or the other to say.
This is what the duty is.
No, my lord, considering that
When
they
the
both
case
are
is
child
very bad.
witnesses, so we have to also see that they are not tutored and they have really seen it as regards how the incident has happened. Only for that matter, I'm just placing it.
Correct,
Certainly it
correct.
is minor, but whatever. We witnessed the whole incident. Thereafter, father somehow managed to come to our courtyard and fell down here. Well, look here, one more thing, my lord. PW5, if your lordship remembers, have said that when they went towards the father threw the knife towards them.
The accused.
Accused. So that part PW6 doesn't say. Then page 25. Then I informed elder brother Bimal, who was sleeping. These are all consistent, my lord. Then elder brother Bimal went to the police station for lodging a complaint. The accused person was kept tight in his house prior to informing police about the incident. Later on, police came to our house and on being shown the knife covered with a piece of cloth in the rear side of the house by accused, police seized the same. I was present while the accused showed the knife in the backside of the house. Here they say it's a knife. The handle of the knife was wrapped with a red cloth, and today I have seen the knife in the court. And the rest is the exhibit. Now in cross, my lord. At the time of the incident, we were inside the house. The house of our uncle is situated in the backside of our house. The pruning knife, which I have seen in the court today, is my father's pruning knife. So the knife, which belongs to the father. I don't know how many persons were there in the house of my uncle. There are 6 members in the family of my uncle, auntie, and their children. It is not a fact that I did not state before police that the accused was kept tight. It is not a fact that I did not state before police that the accused concealed the knife. At the time of the incident, electricity bulb was on. When the hue and cry was raised, my elder sister and I came out and witnessed the incident. It is not a fact that the accused did not cut father. Now here, during cross, he clearly says that at that time he was inside, and when they heard the hue and cry, they both comes out. This could be little relevant, my lord.
Where?
Your lordship will see on the top of the cross, just at the beginning of the cross examination. At the time of the incident, we were inside the house. Your lordship got that?
Yes.
Now, if your lordship kindly see the last sentence in that page. At the time of the incident, electricity bulb was on. When the hue and cry was raised, my elder sister, PW5, and I came out and witnessed the incident.
But
Now-
you got to keep in mind the fact that he was called out.
My lord, why I point this, because now I'm taking your lordship the 313. Now, if your lordship kindly come to the 313 statement, which is at page 39. Well, I'm sorry, I'm jumping from here to there.
No,
I'm
no
just
problem.
clearing 39. 313 statement. One of the answer at page 40 is relevant. The first question number 4, the answer. I do not flee away from my residence, but I went to the residence of manager of tea garden to inform the matter. So here also he explains that he did not run, he went to inform the manager. Then at page 44 now, if your lordship kindly come.
Yes.
Well, I have not pointed down, but your lordship will see he admits the fact that the father died and he was there, and these two witnesses have also seen. All these things he admits. The questions have been put and he admits. He have said yes.
Where?
Yes, I should have pointed that out. Page 42, if your lordship see, question number 18. PW5 further, sorry, question number 16 first, your lordship will see. PW5 in her evidence that on the date of occurrence, her father went to the residence of her uncle. You abused him with filthy language and asked him to come out from the residence. What do you want to say? Answer, yes, he admits. Then question number 18. Though he denies question number 17, that is about he pushing him on the ground and cutting. That part he denies. But question number 18, if your lordship see, further, PW5 further deposed in her evidence that she had seen the whole incident from her residence. What do you say about that? Yes, she was at that time present on the veranda of her house. Then your lordship will kindly see question number 24. PW6 deposed in his evidence that on the date of occurrence, while he along with his elder sister were waiting for their father, and while their father came home, you called your father outside. What do you say? Yes. PW16, PW6 further deposed in his evidence that he had seen the whole incident. Answer, yes, Munni and Rahul were present in the residence at that time. That is PW5 and 6. Now your lordship will kindly see page 44. So he admits their presence, he admits everything. Only thing he explains in what situation the death occurred. Answer, question number 33. On the date of occurrence, it was Magh Bihu, Uruka, and while my father came from the residence of my uncle after the Uruka feast, I called him to come outside of the residence. He calls him. Then my father came with a column kotari and chased me.
What is this column kotari?
Pruning knife.
Pruning knife.
Pruning
Okay.
knife. Later on, a scuffle took place between my father and me, and both of us are in an intoxicated condition. Due to the scuffle between us, my father somehow received cut injury on his neck. While I have not found any response from my father for a while and saw injury on the neck due to fear, I fled away some distance away from my home. But later on again, I returned and saw that my father somehow managed to go to his home and found him lying in front of the doorstep. At that time, I found my father on dead condition, and due to fear, I hid the knife on the backside of the residence and went to inform the matter to the garden manager about the matter. While I was about the reach the residence of the manager of the tea estate, my brother PW1, so and so, some neighbors, caught me and tied me with a rope in a tree in front of our residence. And while police personnel came, I had shown the column kotari to the police personnel. I had not caused cut injury to my father intentionally. So this is his 313 statement, madam. So perhaps here the defense that he's trying to show is that there was no intention. The exceptions and second part, if 304 gets attracted. But the prosecution story otherwise does not support the, there is nothing on prosecution side to show that what the explanation that he has put forward is correct, because there is nothing.
And these questions have not been put to the witnesses. With regard to, you see that he brought out the
Yes, those were not.
katari,
No,
those knife and all.
no, these were not.
But this is only in his explanation he is
Correct.
giving.
Correct.
So
Correct. And if we have to
This is done-
believe
This
the,
is done after the examination is over.
Correct,
313 is
correct.
recorded.
So if these things had been, if the witnesses had been confronted with these aspects,
something may have come out.
yes.
Because one of the witness, of course, said that they used to fight occasionally. Lordship in CPW two.
Fight occasionally,
PW
meaning physically fight or what?
No,
Or,
father-in-law
argue?
used to disturb him.
Huh?
PW two said that, and there is an extrajudicial confession also, I think, before police came in the picture.
Extrajudicial, my lord, are weak piece of evidence. Why I
Yes.
did not say, because though I pointed out during cross, they both said that they did not say it before the police. So if that was there, they should have said it to the police. Anyway, even if we don't take there is no doubt that this has happened. Now, the whole thing is whether the version of the PW 5 and 6 is correct or the 313 explanation is correct. I think it is only that, because if the 313 explanation is to be believed, then of course 304 part 2 will get attracted. But if the PW 5 and 6 is to be believed, then it is shown that it was his intention, because he called the father, he called him out with filthy language and he cut him. So then it would perhaps become difficult to convert it. So now the whole thing is the confidence that your lordship will get from PW 5 and 6. That is the main thing. If your lordship believes that it is completely trustworthy and they have said what they have seen, then perhaps it becomes.
You see, the problem that we are facing
My
is
lord.
that the answer that they have given to question 33 has not been put to the witnesses.
Well, generally what happens, my lord, she is right, my lord. 313 is at the last.
After
Now
the examinations are
it
over.
was normally it was for the defense to get himself either exhibited as a defense witness, because then your lordship could, because now of course your lordship can look into the 313 explanations, but he is not examined as a witness, and he neither brought anyone to show that this is that his version is correct. There is no defense witness. It was his.
Is there any suggestion given to the witnesses that the pruning knife was brought out by the father?
That is difficult to believe, because none of the witnesses have found any knife near the father's body. Nobody has
that
said
nobody
anything.
said. Nobody says
There
who
was-
carried the knife.
Yes. There was
except
only
the-
one knife, which was at the back of the house.
Except 313, he says that that's the father who comes out with the knife. 5, because if your lordship sees 5 and 6, they don't mention who's carrying the knife.
So, yes, so it's very difficult to come under the exceptions, I think.
Only thing, PW2,
No.
lordship can see PW2, their lordship can bring it in the quarrel part, PW2, page number 12. A few lines from the top, 2-3 lines, lordship will see
Oh,
the
yes,
first, second
yes,
line. PW2 is the
On being asked, the
son-in-law of
accused
the
replied
deceased,
that
yes.
as my father-in-law was disturbing him, he had hacked him.
Hmm.
But again, this he did not tell before the police. During cross, this question was put. This was not told before police. But generally, why I say it is not told before police, because if it was so, then of course, in the very first chance when you are giving your statement to police, you would have said it. Now,
No, where are you? Which
page 12. Page
Page
12,
12, yes.
fourth
12.
line from the top. On
On-
being asked, the accused replied that as my father-in-law was disturbing him, he had hacked him. Now, this, your lordship will kindly see the last sentence in that page during cross. I did not state before police that the accused person had hacked his father because the latter was disturbing him.
But this contradiction is not proved. I mean, in
But
the
this is
police
how it is-
officer, but I mean, during the examination of the police officer, this contradiction was not brought before the police. PW1, he speaks of 3, he speaks of.
But you see, there is a lot of blank spaces. First of all, the deceased was having food in his
Brother's house.
brother's house.
That was a day of Uruka.
There is nothing to show that the appellant was also having food there.
Correct. Why the fight took place?
How did
motive,
it start off? The only
Nothing.
thing that is
Nothing.
discernible from the other evidence is that he was called out from his residence.
Right. And in fact, PW5 says that we have a cordial relationship with our brother accused. It is only after the incident they stopped talking to him.
Naturally.
So it could be that what 313, what he says, that it is the father who comes out and during the scuffle, that may be correct. And because now the brother has killed, so the other siblings, that version cannot be entirely ruled out also. That
313 explanations has to be taken into some consideration, but then 313 is only
it has-
explaining the circumstances.
no. That
But of course,
paragraph 4,
the court,
it
has to
be
take
looked
into
Yes,
consideration.
I'm carrying the decision.
So Dev, give us some decision.
I have.
It's
Madam, I
provided in
will.
313 itself.
Madam,
no?
before I go to the 313, may I just take your lordship to one decision on the this is 2014, volume 4, SSC 747.
Yes.
This is on the exception. First, I'm giving this, then I'll place the 313 in the child witness. Here, paragraph 24. We are of the view, 14.4 We are of the view that under section 313 statement, if the accused admits that from the evidence of various witnesses, 4 persons sustained so and so, that admission of guilt in section 313 statement cannot be brushed aside. Thus, court in so and so held that since no oath is administered to the accused, the statement made by the accused under section 313 CRPC will not be evidence stricto sensu, and the accused, of course, shall not render himself liable to punishment merely on the basis of the answers given while he was being examined under section 313 CRPC. But subsection 4 says that Subsection 4 says that the answers given by the accused in response to his examination under section 313 CRPC can be taken into consideration in such an inquiry or trial. This court in so and so held that the answers given by the accused under section 313 examination can be used for proving his guilt as much as the evidence given by prosecution witness. So that relying on the subsection 4 of section 313, which reads as follows, the answers given by the accused may be taken into consideration in such inquiry or trial and put in evidence. So the explanation can always be
put in evidence.
And put in evidence. But that and put in evidence for or against him in any other inquiry into or trial for any other offense which such answers may tend to show he has committed. So and is different, my lord. The first part is the answers given by the accused may be taken into consideration in such inquiry or trial. So that has been relied.
But can it stand alone on its own?
There are several decisions which says alone it becomes difficult to convict him, because this is not under oath, but otherwise the explanation cannot be brushed aside, because now here there is an explanation that the accused has put forward, that there was a scuffle, that he did not have an intention.
But the evidence, the eyewitnesses do not show that there was any scuffle.
So therefore, this is one on 313. Now, as regards the child witness, I will 2011 4.
11.4. 11.4, I think is 313.
Move Krishna to क्या? 2005. This is 2002, volume 5, SSC 745. As your lordship.
2000?
2002, volume 5, SSC 745.
745, yes.
Paragraph 17. The Asaniki photostat DC.
2002.
2002, volume 5, SSC 745. Explanation to what latest lecture. explanation দিলে ভালটা উল্লেখ করব explanation আমার যে কোর্স লিখিত বলে হেনা দিয়া explanation Has your lordship got it? Para 17.
No, we have not got.
Paragraph 17. The evidence.
This is
child witness.
2002 3 SEC.
No, 4 SSC, my lord. 2002, sorry, 5 SSC.
3
This is 3 SEC.
2002 3 SSC, that paragraph 16 to 21, that is on about 2 blows. But I may not take it because I thought in case a question comes, then I was carrying it. So, but I'm not placing that right now. To be 2000 to 5 to yeah. Oh, 745. That I was just carrying because I'm not sure what questions may come from your lordship. Because sometimes in such cases, the question that comes is that if there are 2 blows, intention, whether intention, not intention, because generally.
Okay, so 2 blows.
2 blows. Paragraph 16 to 21. Now, in this 745, your lordship may kindly come to para 17. This is on child witness. The evidence of a child witness is required to be evaluated carefully, as the child may be swayed by what others may tell him or her, as the child is an easy prey to tutoring. Wisdom requires that the evidence of a child witness must find adequate corroboration before it is relied on. We have already held that in the present case, we have carefully examined the evidence of the child and the other evidence. And it is only to that there needs a little bit of corroboration. Now, the next is 2011. 2011 4 SSC 786. Again on child witness, here relevant para is 7 to 14. Sorry. Paragraph. I may start from paragraph 9 at page 791. In so and so, this court, while placing reliance upon a large number of its earlier judgment, observed that the testimony of a child witness must find adequate corroboration before it is relied on. However, it is more a rule of practical wisdom than of law. It cannot be held that the evidence of a child witness would always stand irretrievably stigmatized. It is not the law that if a witness is a child, his evidence shall be rejected, even if it is found reliable. The law is that evidence of a child witness must be evaluated more carefully and with greater circumspection, because a child is susceptible to be swayed by what others tell him. And thus a child witness is an easy prey to tutoring. Paragraph 10, so and so case, the quoted paragraph is paragraph 10. The decision on the question whether the child witness has sufficient intelligence primarily rests with the trial judge, who notices his manners, his apparent possession or lack of intelligence, and the said judge may resort to any examination which will tend to disclose his capacity and intelligence, as well as his understanding of the obligation of on oath. The decision of the trial court may, however, be disturbed by the higher court if from what is preserved in the records, it is clear that his conclusion was erroneous. This precaution is necessary because child witnesses are amenable to tutoring and often live in a world of make-believe. Though it is an established principle that child witnesses are dangerous witnesses as they are pliable and liable to be influenced easily, shaped and molded, but it is also an accepted norm that if after careful scrutiny of their evidence, the court comes to the conclusion that there is an impress of truth in it, there is no obstacle in the way of accepting the evidence of a child. So then para 11, the evidence of a child must reveal that he was able to discern between right and wrong, and the court find out from the cross-examination whether that is the manner. So even paragraph 12 is also important. In so and so case, this court held that there is no principle of law that it is inconceivable that a child of tender age would not be able to recapitulate the facts in his memory. A child is always receptive to abnormal events which take place in his life and would never forget those events for the rest of his life. The child may be able to recapitulate carefully and exactly when asked about the same in the future. In case the child explains the relevant events of the crime without improvements or embellishments and the same inspire confidence of the court, his deposition does not require any corroboration whatsoever. The child at the tender age is incapable of having any malice or ill will against any person. Therefore, there must be something on record to satisfy the court that something had gone wrong between the date of incident and recording evidence of the child witness, due to which the witness wanted to implicate the accused falsely in a case of a serious nature. The last paragraph 14. In view of the above, the law on the issue can be summarized to the effect that the deposition of a child witness may require corroboration, but in case his deposition inspires the confidence of the court and there is no embellishment or improvement therein, the court may rely upon his evidence. The evidence of a child witness must be evaluated more carefully with greater circumspection because he is susceptible to tutoring. Only in case there is evidence on record to show that a child has been tutored, the court can reject his statement partly or fully. However, an inference as to whether the child has been tutored or not can be drawn from the contents of the deposition. Now, this is as regards child witnesses. If you look on the lagging, you want to similar, I have given one decision on 313 and 2 on child witness, and this is 2022 9 SCC 766 as regards that, because there is always a tendency of an accused trying to take the defense that there was no intention. How the court has to determine that, because
Yes.
if culpable homicide is there, this is, your lordship can start from paragraph 13. Citation is 2022 volume 9 SSC page 766. The discussion starts from paragraph 17, then at page 778 your lordship may come towards the end, paragraph 13, a quoted portion. May I read that, my lord? The academic distinction between murder and culpable homicide not
This 2022.
22.
Okay. Item 13 starts as on behalf of the state of Kerala.
No, my lord, this is 2022 volume 9 SSC 766 Ajmal versus State of Kerala.
Yes.
Yes. Now, if your lordship comes to page 778.
There is no pagination of it.
You mean
We've got
SSC
just
print
page
diya nahi?
1, 2, page 1, 2, 3, 4.
SSC print nahi. 778. They have actually, this paragraph is a long paragraph which starts from.
How does it start?
It starts from para 17.
How does it start? What does it say?
Paragraph 17 says the distinctive features.
Para 17. That is 17.
That is 7. Now in 17.
You are saying para 13.
No, in para 17 they have quoted few paragraphs. Now if your lordship kindly comes, para 11, then para 12, then para 13.
Okay, para 17, 13.
Para 17.
Okay.
I'm sorry, para 17.
Para 17, 13.
It says the academic distinction.
Yes.
Yes. The academic distinction between murder and culpable homicide not amounting to murder has vexed the courts for more than a century. The confusion is caused if courts, losing sight of the true scope and meaning of the terms used by the legislature in these sections, allow themselves to be drawn into minute abstractions. the safest way of approach to the interpretation and application of these provisions seems to be keep in focus the keywords used in various clauses of section 299 and 300. The consideration that should weigh with courts in discerning whether an act is punishable as murder or culpable homicide not amounting to murder were outlined in Pulchera so-and-so versus so-and-so. The court observed that, quoted 29. Therefore, the court should proceed to decide the pivotal question of intention with care and caution, and that will decide whether the case falls under section 302 or 304 part 1 or 304 part 2. Many petty or insignificant matters, plucking of a fruit, straying of cattle, quarrel of children, utterance of a rude word, or even an objectionable glance may lead to altercations and group classes, culminating in deaths. Usual motives like revenge, greed, jealousy, or suspicion may be totally absent in such cases. There may be no intention. There may be no premeditation. In fact, there may not even be criminality. At that other end of the spectrum, there may be cases of murder where the accused attempts to avoid the penalty for murder by attempting to put forth a case that there was no intention to cause death. It is for the courts to ensure that the cases of murder punishable under section 302 are not converted into offenses punishable under section 304 part 1 or part 2, or cases of culpable homicide not amounting to murder are treated as murder punishable under 302. The intention to cause death can be gathered generally from a combination of a few or several, the following amongst other circumstances. Number 1, nature of the weapon used. Number 2, whether the weapon was carried by the accused or was picked up from the spot. Whether the blow is aimed at a vital part of the body. The amount of force employed in causing injury. Whether the act was in the course of sudden quarrel or sudden fight or free for all fight. Whether the incident occurs by chance or whether there was any premeditation. Whether there was any prior enmity or whether the deceased was a stranger. Whether there was any grave and sudden provocation, and if so, the cause for such provocation. Whether it was in the heat of passion, whether the person inflicting the injury has taken undue advantage or has acted in a cruel and unusual manner. Whether the accused dealt a single blow or several blows. The above list of circumstances is of course not exhaustive, and there may be several and other special circumstances with reference to individual cases which may throw light on the question of intention. Basically that, my lord. So here, coming back to the case in hand, my lord. That is why, my lord, I was pointing out that small little bit of contradictions which was there as regards the manner the blows were inflicted. In case, my lord, that could be of some, if it raises an alarm, my lord, only to that extent. Otherwise, there are clearly two versions before your lordships. If your lordship accepts the versions of the two child witnesses to be trustworthy, then of course the conviction stands as it is. However, if your lordship has a doubt as whether they are saying correctly about the manner in which the blows were inflicted and the version of the accused in his 313 may perhaps be correct, then of course 304 part 2 may come in. And there is no other witnesses who have seen it. It is only the two child witnesses. So there is no independent corroboration from any other witnesses as regards what happened. Though all the other siblings in their evidence have said either the daughter or the son has gone and called them. So that much is there. And in fact, their presence is absolutely not, there is no doubt, because the accused himself admits that they were there. The only thing is how it has happened. Whether it is the father who started it, who came out with the knife, or it is the accused who started it. Because the accused also admits that it is he who called out his father. That part the accused admits. But he added that it is the father who comes out with the knife, abuses him, and then they got into a scuffle. Let's, yes, read your please.
As far as the homicidal death of the deceased committed by the accused is concerned, PW 5 and 6 are more or less, it inspires the confidence because the root of the case, the how it is committed, those things, both of them states in a similar manner. Father went out for dinner and then he came back, he was in the house. Accused called him from outside. Father went out, they also followed. And then accused had hit the father on the road. Somehow the father reached the threshold of the house and the incident came to light. As far as this part is concerned, there is no inconsistency, there is no contradiction. And the child witnesses, they had not spoken about any quarrel, as the accused had said. None of them had said that there was any fight, anything. Simply he calls, father goes out and he hits. This is what they have said. Apart from that, dying declaration, of course, there is a contradiction, but PW1 had given an explanation to the contradiction saying, I did not state it before the police because police already knew it. This is what a kind of explanation that he gives. So coupled with the evidence of the child witnesses and the dying declaration, I think the homicidal death committed by the accused is proved. As far as this 313 evidence is concerned, there is, of course, a decision 2011 4 SCC. It's in my, of course, I'll give that page, that site, the printout. There, 2011 4 SCC 786. There, the Honorable Supreme Court has said. I'll just read out very slowly the paragraph. Here, the Honorable Supreme Court has said that at 313, the accused has a duty to furnish an explanation as regards any in the other paragraph. It is a subtle principle of law that obligation to put material evidence to the accused under 313 is upon the court. No, even prior to that paragraph I'll read. The statement of the accused made under 313 can be taken into consideration to appreciate why, in what way it will be put into consideration. This is what troubles the Honorable Supreme Court. Now, what it is said is, can be taken into consideration to appreciate the truthfulness or otherwise of the prosecution case. It's not, it cannot be taken what he has said in toto. It will be used for appreciating the truthfulness and otherwise of the prosecution case. However, as such a statement is not recorded after administration of oath. And the accused cannot be cross-examined his statement so recorded under 313. And therefore, it cannot be treated as an evidence under section 3 of the Evidence Act. So as far as 313 is concerned, it will only be taken into consideration in order to see whether the prosecution story is correct or not. It will give a lend of assurance. Here, what he says is that I called, that part is okay. Father came out, he also came out with a pruning knife. We had a scuffle, and that in the scuffle, father got hit.
He also came out? What do you mean?
Father also came out with a pruning knife.
So he had a pruning knife already.
Yes,
earlier,
this is what is in 313.
No, that is not what
He didn't say he also came. He said he called, father came out with a pruning knife.
So what the defense is trying to imply?
No, I'll just read it out
What
again.
he's trying to imply is that the pruning knife was brought out by the father during the scuffle.
Father came out with a pruning knife and chased me. Achha, he did not have, he used his father's.
Yes.
But one thing is surprising, the son had said that pruning knife belongs to his father's.
That is the deceased.
Deceased.
Belongs to the deceased.
This again corroborates his statement in 313.
So
He did not say.
PW number?
PW number 6.
He mentioned that the pruning knife used belongs to his deceased father.
Father.
he says, PW6.
This, of course, corroborates the statement of 313. Lordship will find it at page 25.
Pruning knife belongs to his father.
Which I have seen today is my father's pruning knife.
Page?
Page 25, cross-examination, second line. সেইটো অকমান corroborate কৰে। তেতিয়া বাপেকে যদি লৈ আহিছে,
So,
please, Lordship got it.
it might belong to him, so.
It might belong to him, but pruning knife is kind of similar knife which everyone can have.
But regular kitchen knife.
Kitchen knife. But how can he recognize to such an extent saying that it was his father's? He being a 10-year-old child. But then that statement is there.
Is he pruning what? Pruning the hedges or what?
It's a no,
No, I'm sorry, my lord. I have to correct myself, my lord. Pruning knife would be the knife which is used for cutting those logs and all. Like they are tea gardeners. So I think
Or
it is
logs
that.
of tall grass also.
Maybe. It's
Kasi
pruning.
type,
Tall
kasi
grass.
type.
So tall grass will be that
Huh.
curve.
Correct.
With a
The
bend in the
curve,
front.
Yes.
Ah.
It is.
So
probably
that is
that.
not a kitchen knife.
That's not a kitchen knife. I said correct.
That is seized. Lordship can seize the caesarless ones. The
So how does
pruning.
it matter? Unless there's a photograph, how do we?
But then some kind of an
Anyway,
explanation.
but when you think about it, a pruning knife,
Huh.
if it's for pruning grasslands or for hedges,
Huh.
then it's slightly bigger than a
Yes.
kitchen
Hmm.
knife and with a curve.
Hmm.
Now,
The handle is made of 2 pieces of
only thing
timbers.
is that the issue of who has brought out that knife, who has brought it, in whose possession, that is unclear. Though the evidence does not suggest that there was any scuffle
Hmm.
or any quarrel. It just shows that
Hmm.
straight away he started hitting him
Hitting
and
him.
pushing him.
Yes. And even extrajudicial confession, which is contradicted, he said that I have not stated before the police.
Who has not said?
PW2 himself said that this statement I did not state it before the police. So the contradiction is stands proved. So at best, we can take this extrajudicial confession for conversion, I'm saying. That father-in-law was disturbing him and he attacked him, disturbing him. So there was something in between them.
But where is the evidence?
Apart from this,
That
which
way,
he has contradicted.
that means they're going to put the 313 statement in a higher pedestal than
They
the
cannot.
evidence that has been recorded.
It can be only
And
used for.
that will be dangerous for the subsequent cases.
Yes, it cannot be done also. 313 only to appreciate the evidence of the prosecution case. Here, apart from PW2 statement who said there was extrajudicial, which he contradicted, there is nothing on record to show there was any quarrel, there was any some kind of a fight between the father and the son. So bringing it down to 304, of course, Lordship can see it, section 300 once. 300 before going into the exceptions. Okay. Before going into the exceptions, there are few clauses to show whether how to gauge the intentions. What we will see section 300. Section 300. 300, it starts with, except in cases hereinafter accepted, culpable homicide is murder if the act by which the death is caused is done with the intention of causing death. Or secondly, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. Thirdly, if it is done with the intention of causing bodily injury to any person and a bodily injury, this is not relevant. Fourth, if the person committing the act knows that it is so imminently dangerous that it must in all probability cause death, or such bodily injury as is likely to cause death, commits such act without any excuse for incurring the risk of causing death or such injury as aforesaid. This 4, he is saying he had no intention. 4, but this is hitting was on the hand and the neck. Had it be only on the hand, then of course, no intention. But Lordship can see the post-mortem once to what extent the injury was done.
Yes.
The post-mortem doctor is PW 8. No,
Page?
8. 90 and 8. It was almost shivered. Oh, it's very deep. It was almost shivered.
Page?
Page 29. 29?
Injury is not page 87 of the
Post-mortem. Injuries are at page number 30. This is the examination of the doctor. Page number 30. Did your Lordship get page number? Same things in the post-mortem report.
Yes.
Incise injury of size 12 centimeter and 2 centimeter is present over the frontal and left side of the neck, horizontally placed. So it's 12 centimeter. 1.5 cm below the thyroid cartilage. The skin, muscle, vessel, and part of the trachea are cut transversely. Margins are clear-cut and well-defined. Clotted blood found adherent to wound margins, which resist tapping water. And then the other injury is on the hand. Somewhere I got it was almost shivered. No, I get it. No, it was shivered, nice.
Quite deep.
Quite deep, 12 centimeter. Neck as described. So the hit is quite hard.
12 centimeters is quite a wound. We are the 12 centimeters will be how much? 6 centimeters is this much. What is it 12 centimeters? This is 12 centimeters.
This much.
So
almost the neck.
Yes, and 2 centimeters deep. That means around this much. Quite deep.
12 centimeter into 2 centimeter. In the frontal and the left side, this side.
That is vital part.
So as far as homicidal death committed by this person, there is ample evidence. 5, 6, 164 statement corroborating.
So will it come under the exceptions?
Exceptions again, 1, 2, 3, and 4. Grave and sudden provocation, there is nothing. 4, without any premeditation in a sudden fit of anger after
There is
a
nothing
quarrel.
to show that.
There also evidences are lacking. 313 at best it can lend assurance to the prosecution case or it has to be considered. He has of course admitted everything, only said that it was not intentional, it was after a fight. And they were
But
both
that is not corroborated by any evidence.
not supported by any
Not
of them.
supported.
Intoxicating part is also not there in any of the evidence.
Postmortem also I checked, there is nothing. And then no contents.
Oh,
of
no alcohol and all.
Alcohol does not play a role out here. It's nothing. There's either for the appellant or for the other side. There's nothing. In fact, for the appellant, I think they said the deceased. I mean, that it was said somewhere that he used to drink, but he didn't drink that night or something. It is there.
Correct,
Acha.
correct.
Huh.
That is there.
So if he didn't drink that night, then
And
well,
that postmortem also does not suggest that there is any alcohol. So that will not come.
so that alcohol.
So
part
only
doesn't-
only part is that pruning knife belongs to the father. That statement of
I have
PW6.
taken a print of the pruning knife, Malak. Just to, it's what your lordship had said. That curve.
Yes.
Yes.
All the persons who work in the fields and the gardens will be carrying this in their waist.
He used to work elsewhere. 1 week before the incident, he came home. And then he called his father on that particular night, hit him. Only the evidence of PW6 pruning knife belongs to the father. That is the only thing that can disturb.
And it's sad how these evidences are taken. I wish some light the prosecution witness have thrown.
Yes.
What to do?
This is the problem everywhere. It's not only here.
Yes. Because we will not know why this happened.
Ah.
Something must have happened. Otherwise,
Yes.
why
Will someone, son come
son
and
will
kill his
kill
father?
his father? Something must have happened. But what happened? Neither the prosecution brought it out,
in fact,
nor the
in one
defense.
case, in some other state, the crime could not be, seen from the evidence in the examination in chief of the victim.
Hmm.
However, not in the victim, sorry, in the examination in chief of the
Eyewitness.
victim,
Oh.
the crime could not be made out. No crime was committed. However, in the cross-examination, it came
Yes,
out.
yes. In
So,
one or few
and
cases,
who- And that is by the defense counsel.
Defense.
naturally. So it happens.
Hmm.
And out here, unfortunately,
So that's
they,
why
they,
when I-
they
as
have
a
not
def-
been examined properly.
When we cross-examine a witness, I'm always very careful not to ask much questions because we don't know what will
Yes.
come up. Sometimes something might come out which the
Yes.
prosecution or the.
Correct.
It's a tricky job. One has to
Tricky
be
job.
very
So
careful.
you've got to be very careful
Mm.
at the time of examination in chief. Just see
Hmm.
if there is something against you, then okay, you can cross-examine. But if there's nothing against you,
Better to not ask.
better not to go too deep into
Yes.
the issue.
True, true.
And PW 5 and 6 cross-examination, nothing was demolished. The statement stands.
Anyway, in this case, it's a clear-cut case.
Yes.
It appears so,
Hmm.
except for the fact that, like you said, the knife belongs to the deceased. But that doesn't prove anything
Yes.
because the appellant is the son.
Hmm.
He can always.
And he
pick it
could have
up.
always
Yeah,
gone
yes,
in
Yes,
and
yes, pick it up.
taken
Yes,
it out.
of course.
He was staying there in that house also.
Yes, yes, yes.
1 week before he came back and he
the
was staying
occupant of
there.
that house.
That
So that doesn't prove
That
anything.
doesn't prove anything.
But I think PW2's statement that he was disturbing him over the long period of time, that can be a fact. But then it was contradicted.
Disturbing, also we don't know
No, what do you mean by
disturbing.
Ah, yes.
disturbing? What do you mean
Correct.
by disturbing? You see, quarrels can happen between
Mm.
family
There
members,
should have been
between
some more elaboration.
son and daughter,
Yes, that
I
of
mean,
course is
son
there.
and father, mother, everything.
Hmm.
It happens.
It happens
it's
in
part
every
of life,
household.
Yes. A quarrel happens between husband and wife also.
Hmm.
The daily life
Hmm.
aspect. Anyway,
Difficult to bring it down, actually.
very difficult. Let us see. We'll reserve the judgment. No time also now.
Lovely.
Deeply obliged.
Lovely.
Third, Mr.
K. Goswami.
K. Goswami, Learned Senior Counsel. Amicus,
Am I?
assisted by Miss
Mr. R. Das, Rohit Das.
Amicus Curiae, huh? Assisted by Mr. R. Das. Also had Miss S. Jahan, additional PP for the state. Hearing concluded, judgment reserved.
Not.
Deeply obliged.
Obliged.
47. Last night.
Appeal is dismissed.
Obliged. Hello.
Number? Number. Oh,
Appeal is dismissed.
obliged.